Greetings, and welcome everybody. Thank you so much for joining us today. We are recording our third episode and we're going to be discussing a case. But before we welcome the professor and get right into the case, let us do our maritime term of the day. So today we're going to focus primarily on bill of lading. So just to give you a simplified definition or explanation of what is a bill of lading. So you can break it down into three. It's a document of title, a receipt for shipped goods, and a contract between a shipper and a carrier. Do not worry, all these terms will be explained as we are discussing the case, so you will be familiar with the terminology. So before we just waste time, let us welcome the professor and discuss the case. Professor, how are you?
Hello, Sharon. It is so good to be back. Thank you for
having
me. It feels like a while since our second episode, so I'm really excited to be doing our third together. We're going strong.
We really are going strong, and the response has just been so positive. So thank you guys so much for the positive response. It's very encouraging and it gives purpose and meaning to our podcasts. And I've also observed that our following is increasing on Instagram. So big ups to that. Thank you so much, Prof.
Excellent. I'm so proud of you, Sharon. You are just amazing. So thank you for honoring me with your partnership and all your hard work. Man, I'm just like, really happy. Thank you.
Thank you so much. So please don't make me cry. It really means a lot coming from you. It really does mean a lot. And thank you so much for being willing to partner up with me. I'm just like a junior in this industry, and you were willing to, take me on under your wing and do this with me. And I believe that it's going to be such an amazing, amazing journey. And I mean, I can attest to the fact that I'm seeing growth. And thank you so much for your mentorship. Thank you so much.
You are very welcome, and I'm playing it forward because someone did the same for me many years ago, as we've both chatted about that.
And I am definitely going to be paying it forward. So, Professor, today we're going to talk about a case.
Yes.
So, just as an NB. Forgive me, I may not be able to pronounce the second party to the case, but we're going to be discussing the case of Primesite Outdoor Advertising versus Salviati and Santori. It's a 1999 case, and as I've already explained, it primarily focuses on the bill of lading.
That's right. So I love this case because it's a go-to for me after I've taught like all the core principles of international trade. It's a go-to case study to show students how the three major contracts of international trade work together, like the sale of goods, the carriage of goods, and the financing of the transaction. So this case has it all. I see it as a bit of providence because there's a lot of bills being mentioned in this case as well.
Yes.
There's the billboards, then there's the bill of lading, and then there's the bill of exchange. So it's just all about bills.
Okay, so Professor, will you just allow me to just give our listeners a brief background of the facts so that they are able to go with us and understand what we're discussing.
Absolutely.
But obviously, you are more than welcome to just interject and correct me if I am mistaken. So the facts of the case are as follows.
Mm-hmm.
The plaintiff in this matter, which was the shipper, it was claiming for damages arising out of a cost and freight contract of affreightment with the carrier being the defendant in this case. So my understanding of the facts is that the shipper had entered into an agreement with the carrier to ship goods, which are billboards, to a company in Belgium, which will be referred to as the consignee. And now the problems arose when the defendant delivered the goods without the presentation of the original bill of lading. And you would recall that I've already mentioned that a bill of lading also serves as a document of title and a receipt for shipped goods. So my understanding as I read the case is that it was necessary that the presentation of the bill of lading should be done before proper delivery could be effected.
Correct.
So the defendant presented defenses to his case, and I'm just gonna name a few that the few defenses that the defendant relied upon to dispute the claim of the plaintiff. So the defendant said, surprisingly, that the bill of lading is no more than a contract of carriage, and there was no proof that there was an implied or tacit term in the agreement that goods should not be delivered without the presentation of the bill of lading. And another defense that they rely upon, that the plaintiff was not entitled to claim from the defendant in terms of clause 45.3 of the trading terms and conditions. So before I proceed with the defenses that they relied upon, I think it's very necessary for me to also mention here that that the plaintiff was claiming from the defendant damages in amount that was lost because the consignee took delivery of the goods, but they never paid for the goods. So now the plaintiff was left in a prejudiced position where they delivered goods, but they did not receive any money. So now they were claiming from that money from the defendant to say, no, you gave away the goods without the presentation of the bill of lading. Therefore, we are claiming from you the money that we could have made from the goods. And now the defendant is saying, well, the goods were delivered to the consignee, which was all that was required from the bill of lading, which is surprising because the first defense they made, they said a bill of lading is no more than a contract of carriage, and now they are saying that they've delivered in terms of the bill of lading, which is a bit contradictory from my side. And I think the fourth or the fifth one that they relied upon is that the plaintiff failed to prove its damages, and that the plaintiff sought to prove its claim in a manner that was inconsistent with this particular claim. So I don't think for purposes of this discussion that the last two defenses will be heavily relied upon, but you will find that the court actually dismissed those defenses. So Professor, is there anything that you would want to add on with regards to the defenses that were made by the defendants in this case, and obviously with your understanding of the contracts?
Actually, you hit the nail on the head with all these defenses that the defendant Salviati Santori tried to make. And you cannot blame them for making all those defenses because they had carried the cargo successfully to Belgium and they felt entitled to be paid for their freight costs. And on top of that, not to be held liable for delivering goods, which is what they were contracted to do in the first place. However, their defenses were not they were denying traditional values of a bill of lading. A bill of lading is a document of title. The person who is a rightful holder thereof has a right to present it to the ship and thus claim goods. But in this case, that never happened. And this is another reason why I love this case, Sharon, because it shows us that in practice, it's not always possible for ship owners to confirm the holder of the bill of lading. It's not always possible for the holder of the bill of lading to present a bill of lading, an original bill of lading, and the ship cannot be expected to wait around at port looking for the rightful person to come and claim the goods. So sometimes there are instances in reality where cargoes have to be dropped off without original bills of lading. However, what will happen is that the person who's usually responsible for the goods in some way, sometimes the seller, sometimes the person who has a right to make decisions over the goods, they can actually issue a letter known as a letter of indemnity, an LOI, to the ship to say, go ahead and release the cargo, but you will not suffer consequences for releasing it without a bill of lading. So this case also shows what can be done in instances like that.
Absolutely.